Hello, my name is Galina Kurdina. I live in Toronto, Ontario, Canada, and I am a victim of psychotronic mind control weapons. I reported about these crimes to Toronto Police Services many times, but they refused to start an investigation. I filed a statement of claim against Toronto Police Services Board, RCMP, Lei Chen, Rengxian Li, and Doctors Pliamm in 2008. I would like to read an excerpt from this statement of claim against Toronto Police Services Board. Plaintiff has exhibits. Plaintiff, it's me, since I filed this statement of claim. Plaintiff has exhibits that show large and dangerous life-threatening surges of electrical and radio frequency energy possible only from man-made powerful internal or external electric and radio frequency transmitters. Plaintiff has a proof that she is under health and life-threatening attacks of psychotronic weapons. The crudest forms of these attacks could be used to distract individuals. Toronto Police Service has a duty of care to plaintiff. Plaintiff has reported 7 times to Toronto Police Service, provided them with her symptoms and the names of suspects, Lei Chen and family of landlords at 73 Mossbrook Cres, Scarborough. The police refused to start an investigation. First and second time, she reported to the Police Division number 41 in January 2006. Both times, police officers sent her to a health department and refused to start investigation. Plaintiff reported to the Police Division number 52 and said to them, name of suspect Lei Chen, but police officers refused to investigate. Plaintiff reported to Police Division number 33 and talked to Police Officer Thompson on the 29th of December 2006, told him her story and provided him with the name of suspect Lei Chen. He refused to start investigation and suggested to go to a doctor. Plaintiff reported to Police Division number 33 and talked to Police Officers Castle and Nicholas on the 16th of December 2007. She told them name of suspect Lei Chen, but they refused to investigate. Police Officer Castle asked plaintiff twice, "What do you think? What government affects you? Maybe Russian?" Plaintiff answered that she strongly believed it was the Canadian government. At least it sanctioned all these attacks because police, RCMP, and other government structures had been aware of these experiments since January 2006 but didn't start investigation, despite the fact that the experimenters lived and visited the house at 73 Mossbrook Cres, Scarborough, where she rented an apartment, and she heard their Russian speech, saw their faces, and reported it to the police with the names of the suspects. Officers Castle and Nicholas gave plaintiff a lift to the Scarborough Grace Hospital to a psychiatrist, member of a crisis program. Police officers Constable Corby and Constable Khan from the 33rd Division came to plaintiff apartment on the 6th of February 2008. Plaintiff talked to the police officer Gottschalk in the 33rd Division on the 24th of April 2008. He created a file in their computer system. It was done 2 years and 3 months after the first report to the Police Division number 41 of Toronto in January 2006. Plaintiff is afraid that the police may just come to the 73 Mossbrook Cres, ask Lei Chen whether he carries out these experiments, and close the file with his answer no. Plaintiff and her landlord reported to the Police Division number 33 that she recorded more than 200 voltsmeter for radio frequency 10 MHz many times, but nothing has changed so far. The judgment of police is criminal since the electromagnetic energy and psychotronic weapon attacks damaged health, tortured plaintiff, deprived of job, exhausted financially. Plaintiff reported symptoms of well-known electromagnetic energy and psychotronic weapon, but police officers referred her to health departments. If they believed that the plaintiff was delusional, this judgment was criminal too, since any person, even a delusional, must not have been affected, tortured, or killed. The police had to start investigation in 2006 and find out that plaintiff was affected by electromagnetic energy and psychotronic weapon. The Toronto Police Service breached the duty of care to plaintiff. They refused to start investigation after plaintiff had said to them her symptoms and name of suspect. Instead, their doing nothing allowed further experimental activity and therefore harm be done for her. Doing nothing of the police in this situation is actually a form of sanctioning experimenters through their inaction to stop them. Plaintiff has reported to the Toronto Police Service since January 2006. She was diagnosed with psychosis and delusional disorder in June 2006 as a result of refusal to start investigation, which allowed further electromagnetic energy and psychotronic weapon attacks, and therefore harm be done for her. There were no other reasons to develop psychosis and delusional disorder. Plaintiff also claims health damage of other kind as a consequence of electromagnetic energy and psychotronic weapon attacks. It identifies the Toronto Police Service as a guilty party failing to start investigation, keeping aid from reaching plaintiff. The actions of defendant are against the laws and prevent such activities. The actions of defendant are against the laws that prevent such activities and need to be stopped by the court. This complaint proves that the Toronto Police Services were negligent. One more example substantiates this claim. Plaintiff sent a FOIA request pursuant to an Information Act pertinent to devices emitting radio frequency. Defendant, it means Toronto Police Services, denied any knowledge of required information. Plaintiff provides evidence defendants were willfully negligent in responses by finding such information on defendants' own websites or with reference from them on those subjects. Many cars and bicycles in Toronto are equipped with tracking chips emitting radio frequency, which help to find lost or stolen vehicles. These tracking chips are working through global positioning system. After filing of this statement of claim with the Superior Court of Justice in Toronto, I received statements of defense from Toronto Police Services Board, RCMP, and Drs. Pliamm. Lei Chen and Rengxian Li, who were mentioned in this statement of claim, I would like to show it. Lei Chen and Rengxian Li, they were mentioned as perpetrators. They didn't respond. And I noted them in default on the 24th of November 2008. If a person is noted in default, it means that he admits all accusations stated in statement of claim. I noted Lei Chen on the 24th of November and Rengxian Li I noted in default on the 6th of November 2008. There was a motion on the in December 2008, and Justice Romain Pitt dismissed my statement of claim, my action against all defendants on the 16th of December. I got this order dated the 16th day of December 2008, and it states that motion made by the defendants Dr. Sara Pliamm, Dr. Naomi Pliamm, Dr. Yu Pliamm, the Toronto Police Services Board, and the Attorney General of Canada for an order to strike out the pleadings without leave to amend for failure to disclose a reasonable cause of action and for failing to comply with the form of pleadings as provided by Rule 25, and a motion made by the defendants Drs. Pliamm and Attorney General of Canada for summary judgment was heard on the 5th of December 2008 at the courthouse 393 University Avenue, Toronto, Ontario. On reading the materials of the parties and on the hearing their submissions and on issuing the endorsement dated the 16th of December 2008, this court orders that the pleadings of Galina Kurdina be struck in their entirety without leave to amend pursuant to Rules 25 and 21 and 25 of the Rules of Civil Procedure. This court further orders that the motion for summary judgment of the Drs. Pliamm and the Attorney General of Canada is granted. This court further orders that the defendants may seek costs on this motion and that submissions regarding costs are to be made within 10 days of the date of the endorsement. Nobody made these submissions regarding costs, so I didn't pay anything to Drs. Pliamm, RCMP, and Toronto Police Services. So it means that Justice Romain Pitt dismissed my pleading against Toronto Police Services Board, Attorney General, RCMP, Lei Chen and Rengxian Li, despite the fact that Lei Chen and Rengxian Li were noted in default, actually admitted that they were perpetrators of this crime. Furthermore, I forced RCMP to start investigation of these crimes in 2009. RCMP officers came to Lei Chen at 73 Mossbrook Cres, Scarborough, Ontario, and he confessed to RCMP officers that he studied psychotronic weapons and their influence on psyche of people. So he perfectly understood this statement of claim and what was written about his crimes. In 2010, I received a letter from the Superior Court of Justice. Here it is, that my action was dismissed for a delay. Take a look. This is the same action, Galina Kurdina versus Toronto Police Services Board, RCMP, Attorney General, RCMP. This is the same, Lei Chen, Rengxian Li, and Drs. Pliamm, Sara Pliamm, Naomi Pliamm, and Yu Pliamm. It states the plaintiff has not brought this action to conclusion or set it down for trial within the time prescribed by Rule 48.14 or such other time as was prescribed by order as has not cured the default. It is ordered that this action be dismissed for delay with costs. Signed date the 29th of September 2010 and signed by Susan Puran. I contacted the Toronto Superior Court of Justice and brought them papers, endorsement and order of Justice Romain Pitt, and eventually I insisted and forced them to put right information on their website of the Superior Court of Justice, And this website contains endorsement of Justice Romain Pitt, not order. You can find this endorsement on their website. Number of docket, number of file is CV-08-355-105. As I can, as I guess, there was an attempt to substitute this new order for a real order, genuine order, signed by Justice Romain Pitt on the 16th of December 2008. One more time, my action was dismissed despite the fact action against Rengxian, Li and Sara, Lei Chen was dismissed despite the fact that Lei Chen and Rengxian Li were noted in default. It means that they admitted that they committed these crimes against me.